Good evening. This is John Milburn for Laws 11059, Statutory Interpretation. This is week 4 of 2017, term 3. Tonight we are catching up on material from week 3 and we'll introduce the material from week 4. Just as a reminder, next week is the university holiday, so there'll be no live session next week. Week 5 is 2 weeks from now, and we won't be having a live session in week 5. I'll be recording and uploading some material in relation to legal research. Those of you who have completed Introduction to Law or will be doing Introduction to Law at the moment will see that there's a crossover between that content. If you have already done Introduction to Law, I urge you to go through the process of legal research once again, but this time do it within a specific context of statutory interpretation. Now, we know the Act that will be the main part of the assessment in the take-home exam. So my suggestion is that as you're considering the material that I put forward on legal research, do it in the context of that Act, even though I won't be specifically speaking about that Act. Now, speaking of the exam and assignments generally, I guess you have some questions, and please feel free to ask those questions on UCrew. In the meantime, we have, I think, one question now. Sarah?
Yes. How far is too far under the word count for the first assessment? And does it matter if, say, only 500 words for part 1 and then 1,500 words for part 2 for that assessment?
Good questions. My general philosophy is that I'm not too tough on word counts. Each unit coordinator will have a different approach, so please don't assume that what I suggest will work for other unit coordinators. If you feel the need to go over the word count, feel free to do so, but if it's more than about 10%, I'm really going to ask myself, did you need to go that far? When it comes to being under the word count, generally speaking, if you're less than 75% of the word count that I have recommended, then you might be asking yourself whether you need to add something else to the material. So as a rule of thumb, you'd want to get to about 75% or more. If you're less than that, I hate to use the word padding, but you can value add, I think, is a better approach. If there are word counts within different parts of the overall assessment, I'm usually very happy for you to amend the word counts to suit your response, because in many ways the word counts that I suggest are framed around a way that I would probably approach a problem. But where the problems are interrelated, you may adopt a different approach, which means adopting a different word count. So I'm probably more inclined to look at the total rather than the individual components. And even if the questions are separate, I still work to that same general philosophy. So don't worry too much about word counts with me. I think, some of the things that I'm really keen on, presentation, internal consistency, making it look the part, but word counts, that's not such an issue for me. All right, I hope that answers your question, Sarah. All right, now, a question came through on the chat facility. What's the legislation that you'll all have to read very carefully this term, specifically for the purpose of the examination? The Work Health and Safety Act. Thank you, Sarah. That's the Queensland version. And particularly, 2011, particularly have a look at the amendment from this year. All right. And the reason I'm mentioning that is I want you to consider that Act actively while you're reading the material. So don't just read the material and let it gloss over you. Read the material about purpose, context, whatever it might be, and apply it to that legislation, knowing that your exam question will be based on that legislation. All right, any other questions? All good? That's it. Ben's got it. Work Health and Safety Act with the 2017 amendment. That's what we're really looking to do. Last week, we were talking about statutory instruments. I wanted to find an example of statutory instruments in practice. It's a very broad concept. So, for example, have a look at a decision of Member Traves in the Queensland Civil and Administrative Tribunal. I'm going to share the screen in order to show you this decision. Hopefully, you can now see a QCAT decision. You'll see this is drawn from Ostley, Goldfield projects against the QBCC. This is a merits review, and the member had to make the correct and preferable decision. Those of you that have studied environmental law with me, if anyone in this class has done that, will know that we speak a lot about merits reviews in that jurisdiction. We do a lot of merits review works in the tribunal as well. So in this case, the member had to consider the correct and preferable decision, the merits decision, merits review decision, relating to a decision by the QBCC to issue a direction to rectify work. Now, the tribunal found, if we look at footnote number 13, paragraph number 13, this, and I've highlighted it there, the rectification policy, which is the rectification of building work policy issued by the QBSB as it was, and I appreciate my internet is unstable, so I'll stop this share soon, was found by the member to be a statutory instrument, and it was applied by the tribunal in reaching its decision. So if you want to look at that case, it's 2016 QCAT 362, and it was a decision from the 4th of October of 2016. All right, Chapter 3. We can move through this fairly briefly. It won't be a long session tonight. I know I say that and then things happen to cause it to go much longer than I expect, but that's all part of it. Age. So if someone is 3 years and 7 months, what is their, when do they kick over to become 3 years? You know, we talk about a 3-year-old person or a 12-year-old complainant, for example. How do we work that out? I mean, if someone is 11 years and 11 months, do we round it up?
Generally, don't we go by their last birthday?
We do. Very good. Thank you, Grant. It relates to the birthday. And Jess says at 12:00.01 on their birthday. Now, when you're reading material, always ask yourself this: how will I justify that answer if I'm in front of a judge and a judge says, well, what's your authority for that proposition? Why do you say that that's the case? Let's say it's a Commonwealth matter. Where would we look? Okay, the Acts Interpretation Act.
Yeah.
Closer. Yes, Tanya?
I was just going to say the same thing as in the Acts Interpretation Act.
Right, we're getting closer.
Or it might be defined in the relevant legislation or statute itself.
Yes, you could, and that was the trick part to it, Ben. That was the little kicker at the end. But before we get to that, where in the Commonwealth Acts Interpretation Act is there a section that deals specifically with the issue of age? All right, we'll have to buzz you all out collectively on that one, section 37A. So have a look at that, where it says, unless a contrary intention appears, which is Ben's point, the time at which a person attains a particular age expressed in years is the commencement of the relevant anniversary of that date of the person. And if we come back to what Jess said, that means 1 second after it clicks over on the stroke of midnight. So we don't get into fine arguments about, well, this child was born at 4 p.m. This offence occurred in the early hours of her birthday. She wasn't technically, we just treat it as the anniversary day. Number. So if a provision says it's an offence to discharge a bomb in a supermarket. Very brave saying that, aren't I? The world has changed so much. Does that cover a discharge of more than one bomb? Can you argue, well, my client is not guilty of... Yes, Sarah?
According to the Acts Interpretation Act, although the section currently eludes me, it says that any use of a plural or a singular shall be such that it refers to the other thing. So if it is a pluralized, it also refers to in the singular, and if it is a singular, it also refers to a plural. So if it's illegal to discharge one bomb, it is illegal to discharge many bombs.
Excellent. Now, are we talking Commonwealth or state? Acts Interpretation Act.
I think that was taken from the Commonwealth one, but I think each state has a relevant similar provision.
It does. So, yes, it's both Commonwealth and state. Can anyone give me the section numbers? 23B, says Nicole. Yes, yes, David?
Wasn't Queensland 32C?
32C. That's it. 23B for Commonwealth, but and 32 for Queensland. Time. If legislation refers to time, it means the standard or legal time in the place where the legislation applies. Section numbers?
In the Acts Interpretation Act, the Commonwealth legislation, it's 36 and 37.
37C was the answer I wrote for myself in the Commonwealth, and 36 for Queensland. And of course, Sarah and others in different states, you'll have your own, but I don't know what they are, sorry. All right, so they're pretty straightforward. Now, a little bit more interesting is the use of the terminology in statutes of may and shall. May I have a biscuit? Shall I have a biscuit? I mean, if someone says, if this occurs, you may do something, as opposed to if this occurs, you shall do something, is there a difference at law? And what is
Yes, I believe the term shall is a more stronger word, meaning that they have to comply by it, whereas may indicates a level of flexibility there.
Okay, so Grant says, good, thank you, Grant. So Grant says, and Sharon agrees, may represents a discretionary power, whereas shall, says Manoj, equals must. Is that always the case?
No, I read some common law judgments that where they used may, it wasn't discretionary. So that it was just in the wording of the statute or a particular section of a statute that people had challenged it, and it was found that may didn't always mean that something could be decided or was necessarily a discretionary term.
And yeah, I agree with you, Ben. It would be lovely if it was a rule that always applied, but it doesn't always apply, and it can apply to different circumstances. So, for example, if a piece of legislation talks about a discretion on a member of the executive who may do something, then if you're a lawyer representing an aggrieved party, you might argue that may really requires a two-step process. The first is, whilst it's not stated, that executive officer shall at least consider it and shall consider relevant circumstances and relevant facts, and only then may they exercise a discretion. So when it says may, does that really mean that they can say, not even looking at it, don't care, too busy, not even going to consider? Probably not. Even though it's may, I think the implied obligation is that they shall at least consider it in good faith and consider the relevant facts. If you can argue that part, you then have a chance of arguing that the decision to do something which your client didn't like was inappropriate or wrong. Now, case law. Ben mentioned case law. always a good starting point in statutory. Yes, Sarah?
Sorry, I just clicked the button by mistake.
By mistake. No, that's all right. Always a good starting point for statutory interpretation is Project Blue Sky against Australian Broadcasting Authority, 1998 194 CLR at 355. In that case, the High Court said, in determining the validity of an act done in breach of a statutory provision, it may easily focus on wrong factors, and the Act will ask you whether it's mandatory or directory, but you need to consider the context and the purpose. So Project Blue Sky is a really good case to argue if you're talking about purpose and context. In pages 40 to 42 of your text, there's a really good example, and that is the case of Animal Angels against the Secretary of Department of Agriculture. It's a federal court appeal decision, and in that case, the federal court considered the Acts Interpretation Act, section 33(2)(a), in determining that the reference to may in section 23 of the Australian Meat and Livestock Industry Act was in fact discretionary. So in other words, when it said that the departmental officers may do something, may give a written notice, a show cause notice, the Act means what it says. So the plaintiff in that case, I suppose, looking to activate the executive to take action against a party that had not treated animals well, sought a declaration for the federal court to say that even though the Act said the Secretary may give written notice, in fact it was a mandatory requirement for the Secretary to give written notice if the facts supported the breach of the legislation. The federal court disagreed, said no, it is discretionary, and it raised this point, and it said, even though the Act says the Secretary may issue a show cause notice if one of 1, 2, 3, 4, 5, 6 things happens, it's still not obligatory for the Secretary to issue the notice because there are other wider issues. And those other wider issues relate to broad policy or public interest considerations. What I guess I'm getting at is this. When you see a provision that says may or shall, you need to build into your toolkit some little flowchart or some basic prompts so that you can argue something either way. Because you will find in practice you argue things either way. So on the one hand, you may advance an argument like I was saying before about the obligation to at least consider it and do so on the relevant facts. Another is if you're trying to support the department in not acting, then you argue these broader policy and public interest considerations. The authority for that is the Animals Angels against the Secretary case. So that case showed that if the legislation used the word may to confer a power in giving permission to allow something to be done, then it is genuinely up to the holder of that power to determine whether to exercise the power or not. However, generally, the holder of the power has a duty to at least consider whether to exercise the power. We see that in environmental law regularly. Again, in your textbook, we have an example. So in Yasmin against the Attorney General for the Commonwealth of Australia, 2015 FCA 145, the court held that the term may be referred by the Attorney General to the Court of Appeal was discretionary as to the outcome of the exercise of the power, and not a discretion as to whether to reach a conclusion at all. So the court said that the attorney had to consider the material and could then exercise the power. So in that regard, the officer, the executive officer, the attorney in this case, must consider the context and consider the consequences of the power not being exercised both to the individual and the broader public, and then make a decision. But the big mistake is not to give consideration to it in a proper manner. Does that make sense? So what we're really saying is that may generally means may, as in discretionary, but there are some factors that go with it, and sometimes it can be a positive obligation, but not usually. I hope I've explained that reasonably well. Ben?
So in in short words, and a statutory instrument, or where a statutory instrument is involved, the only obligation conferred under may is that there's consideration and judgment given by the person who's in charge or referred to by the statutory instrument.
Yes, in general terms, I'd say that's right, with probably one other caveat, and that is that they must properly consider the relevant circumstances and the relevant facts.
So context and purpose again.
Yes, context, purpose.
Beautiful.
Okay, thank you. All right, so Jess, but whatever interpretation of the word may is used, you must be able to argue or support your choice in context, and that is correct, yes. Always look at the context, and that's just a general rule of statutory interpretation. Now, commencement. We know this. We know when an act commences. A refresher. Commonwealth. When does a Commonwealth Act commence? And what's your authority for the proposition?
Well,
Sorry, was that, yes, Grant? All right, we're getting some answers coming in. Ben, Jess, say 28 days. Sharon says Section 3A is the authority, and that is the Acts Interpretation Act. So that's it. It commences on the 28th day after the day on which the Act receives the royal assent. That's the Commonwealth position. Oh, Jess has beat me to the punch. She's already telling me Queensland. Excellent. Immediately after royal assent is given. What's the authority for that? Again, we know it's the Acts Interpretation Act. What's the section? Are you sensing a theme here that when you're dealing with statutory interpretation, good idea to have your Acts Interpretation Acts handy, ready to go. 15A, Jess is the winner on that one. Well done. That's it. Ben was reaching for the... Yes, Sarah?
And both of those have the caveat that that's what happens unless otherwise specified in the Act.
Excellent. Excellent. And that's exactly right. And it's a trap for young players. I mean, I don't know. When you're looking at the Act, which will be considered in the examination, maybe there's a provision that says something contrary to the usual provision. I don't know. Maybe there are certain provisions that say, notwithstanding the assent, it will this particular provision will take effect at a later date. Maybe that's something that will be there. Also, Tanya says sunset dates. So Sarah's right. So even though there is that general rule, you must consider the legislation itself because it may enact an alternate commencement provision. I mean, your job practically is to find the date of assent, add the number of days, subject to what the Act says itself. All good? Yes, Ben?
Sorry, inside of that, I was looking at the Fair Work Act, and it's got multiple commencement dates for multiple different clauses and sections in there as well. So that was something I just picked up the other day, and there was sort of 17 or 18 different dates listed.
You're on mute.
Thank you. Thank you. So the issue is compounded by the fact of amendments to the legislation. So we know that legislation is often amended, and you need to consider when the amendment, the pieces of legislation which cause the amendment themselves come into effect. So that means reading the Act, the Amendment Act, consider the Act's Interpretation Act. Grant, did you have something to ask?
Just with what was mentioned with the Fair Work Act, I think there was some sort of transitional period with that. Didn't it end around 2014 though? I mean, I'm not sure if that's, I mean, I just got 2014 in my head. Is that true or?
I can't say offhand, but that would be an interesting one for you, Crew. Sorry, I can't answer that immediately. Does anyone else have a response? I suspect you're right. All right, sorry, Grant, but we might explore that one a bit later. Thank you. All right, so we know that amendment acts will have a bearing on this. So you need to consider the Amendment Act. Now, there are two basic types of Amendment Act. We have what we call an Omnibus Act, which is really a generic act that has the effect of making a slight change to many pieces of legislation. So it might be, you know, it'll be called something generic. But more commonly, when we talk about an Amendment Act, we talk about, you know, the Property Law Amendment Act of 2017, whatever it might be. So the Amendment Act can be in two parts. And in the Amendment Act, it will normally make changes to the Principal Act, and then effectively the Amendment Act dies once it's made that change. Sometimes that sunsetting of the Amendment Act is built into the Amendment Act itself. Other times it's incorporated some other way or it's repealed formally. But anyway, when we have amendments and you have a series of amendments, then sometimes it becomes a little tricky to know whether a particular section has come into effect as a result of amendment, and if so, when does it actually become law? So that's what you need to consider. And then having done that, you need to consider whether it has some degree of retrospective effect, which might seem a bit tricky. I mean, is it possible to have lawful retrospective legislation?
My understanding was that in Amendment Acts, it is possible to have an application that this Act, once assented, comes in retroactively affects up to a previous time. However, that doesn't mean that judgments made based off the original Act during that time are like changed.
Yes, that I agree with that. But generally, legislation will not have a retrospective effect, at least as far as substance is concerned. So you may have to consider whether the Amendment Act causes a substantive change to the law or a procedural change. If it's a procedural change, it's more likely to have retrospective effect. If it's substantial change to change people's rights, then it's unlikely to be retrospective. Possible, but unlikely. Yes, Ben?
Yeah, Marbo is a good,
Yes.
a good way of looking
True.
at that, because if it was going to be a substantive change, it would have changed an awful lot.
Yes, that's right. And of course, Mabo wasn't legislation, but the Native Title Act in 1993, the year after the Mabo number 2, was and did have some degree of retrospectivity about it. So I guess what we're saying is this. When you're considering the question of commencement of legislation, you need to consider the Act itself, you need to consider the Act's Interpretation Act, you need to know the date of assent, you need to do the addition of the date of assent plus either 0 or 28 or whatever it might be. You then have to consider the amendments, when they came into effect, and if so, How do we determine that? Either in the amendment itself or by reference to the Acts Interpretation Act. We have to consider whether the Amendment Act itself dies once it's made the change, which typically it will do. Sorry, I'm using very basic language, imprecise language. And then you have to consider whether the amendment has a retrospective effect, which may have a bearing on whether it's substantive or procedural. So even though it sounds simple, there's a bit to it. And that's where when you're preparing your toolbox, consider these things and have it mapped out. That'll really help you when it comes to the exam, when you're looking at this Work Health and Safety Act. Any questions about that so far?
Yes.
Yes,
can
Jess?
you please explain a little bit the Omnibus Amendment Act type of amendment?
So, for example, you might have an amendment to the, I'm not sure if this is the right term, but say the Penalties and Sentences Act. Often we see now in legislation, penalties are prescribed not by reference to a dollar amount, but by a penalty unit. So it may be that if you commit a certain offence, the maximum penalty is not expressed in dollars, but in penalty units. So what happens then is that 6 months, 12 months, 2 years down the track, there might be an act which says the Penalty Units Amendment Act of 2018. And it might say, in any act where there is a reference to a penalty unit, that amount is now to be construed as $1.15.
So that would be retrospective?
No, generally it's not retrospective. But when I talk about it being an omnibus act, which is really an old-fashioned term, it just means an act which is pretty simple, but it has general effect to make a slight change to lots and lots of pieces of legislation.
Oh, okay. Yeah.
I hope that explains it better.
So it's a little bit more generic across multiple multiple acts.
And if we didn't have that Omnibus Act to amend, we would then have...
You'd have to amend all these acts.
Yeah, you'd have all these separate little amendment acts for just nothing substance. Yes, Sarah?
A good way to think of it is that sometimes collections of short stories or book series will be referred to as omnibuses because they are a collection of multiple separate but related things. Therefore, an omnibus act is a collection of multiple corrections to multiple acts, but because they're all corrections, it's related in that sense. Which might make it easier as like each correction in the omnibus is like a different short story aimed at a different act kind of deal.
Thank you, Sarah. I've never heard anyone explain what an omnibus provision is better than that, so thank you. I appreciate that. All right, so when it comes to retrospective effect, if you want a good case to use, have up your sleeve, consider Maxwell and Murphy from 1957. It's in the High Court, 96 CLR. It's instructive in that the courts may make different presumptions depending on whether it's procedural or substantial in the amendment in issue. It's referred to in your text at page, at 286. Justice Fulliger said the distinction is probably best stated by saying that it's between statutes that create or modify or abolish substantive rights on the one hand and statutes that deal with pursuit of remedies on the other, which is really the procedural aspect of it. So in the former case, there's a presumption against retrospective operation if it's going to affect substantive rights, says Justice Fulliger. In the latter case, on the contrary, the presumption is probably that the amendment will apply to procedural matters even if it commenced before the law came into effect. Not always, but just as a general rule is that presumption that you can draw. I raised that case to highlight the importance of having something to support your authority. So generally speaking, if you wish to make a statement of law we would like to see some form of primary law used by you to support your argument. The primary sources of law, legislation or case law. If you can't find those, then go to a textbook or some other secondary source. Okay, invalidity, briefly. So a court may determine that a statute or part of it is invalid. What would normally be the basis upon which a court would say this legislation is invalid?
If it goes against the Constitution?
Yes. Ultra vires, says Sharon. That's the term I was looking for. And that's right, Ben. It's unconstitutional. It's ultra vires. What does ultra vires mean? And of course, it's Latin. Beyond the
one
power.
where the
Sorry. Yes, Tanya?
No, it's all right. That's exactly what I was going to say. It's beyond the power of the person that's been provided with the authority under that particular piece of legislation.
Great, thank you. And Manoj says, questioning the authority to make the regulation. So where would we find the source of the power, say, for the Commonwealth to make legislation? That took a while. Constitution, yes. And now more specifically, section 51 of the Constitution, spot on. That's always the starting point. So if you're going to attack a Commonwealth law on the basis that it is ultra vires the Parliament, you have a look at section 51. Thank you. All right. Context and purpose. We know that the modern approach, essentially the purpose of approach, some authors make a distinction between the purpose of approach and the modern approach. I'm not sure there is much of a difference, but keep that in mind. So when we look at legislation, we interpret legislation, we know that we must consider the context and the purpose. What's a good case to put forward? A couple of good cases to argue that point, cases that immediately come to mind. We've mentioned one tonight. This is a bit of a memory test to see if you were listening. Blue Sky, Project Blue Sky. Yes. What's another handy one to keep up your sleeve? Just as a, yes, David?
Is this in relation to context?
Context and purpose, yes.
The CIC Insurance Limited versus Bankstown Football Club Limited?
Yes, exactly. And while you were saying that, Melissa put that up on the chat screen as well. I think they're two really handy cases to have up your sleeve. I think CIC is for the first assessment. In your toolkit, make sure you have a few leading cases that you can always refer to as a backstop. Now, David, anything further on that?
Oh, sorry.
No, you're right. Anyone else? Any comments, questions? Okay, here's a quote that I really like. Page 62 of your text. Michelle Sanson says this. It's the introduction. She says, the key task of statutory interpretation is to find the ordinary meaning of the words, not in isolation, but taking into account their context and purpose. Okay, that's what we do. So reading that, what's the first thing we have to do?
Sorry, you won't. Oh, sorry.
Yes, Jess?
You won't look at it from a bias perspective, but you have to look at it in context rather than just look at the words and not the purpose of it.
Yes. So when you say we look at it in context and purpose, Tanya, what do we look at?
Would you say you have to
the
read
ordinary
this?
meaning?
Oh, the ordinary meaning. Yes, Tanya. Yes, and Ben, you wanted to say something as well, and then we'll come back to you, David.
Yeah, so context is the ordinary meaning, but also in relation to the whole rest of the Act.
The whole rest of the Act. That's important as well. Thank you, David.
I was just going to say the same as Ben, where you've got to read the whole Act in order to help interpret the context.
Okay. So, yes.
And understand the purpose. And obviously the explanatory notes or memorandum and second readings will help with that.
Yep. But I'd go to those after you look at the objects clause. So the reason I'm sort of stopping now and just stressing this point is when you're preparing your toolkit, you have to work through these sorts of statements that you read in the textbook and say, okay, how am I going to make this my own? All right, the first thing I'm going to do is look at the ordinary meaning. Second thing I'm going to do is look at the objects clause. Whatever it might be, I'm not trying to say this is the answer, but I'm saying read these statements by the judges, read the legislation, such as Section 15AA of the Commonwealth Act, and read the comments by authors such as Sanson, but then create your toolkit. So when you have a real life problem, you can say, okay, here are the steps that I'm going to adopt. Does that make sense? That's what I want to see in your toolkit. It's not necessarily going to be a right or wrong answer. There might be some answers that are probably wrong, but there's not necessarily going to be one single correct approach, is really what I'm trying to say. Where's maybe a good place to start to think about the flow chart when you're considering this, Ms. Tanya?
Back page of the text.
The back page of the text, yeah. If you've got your text there, just have a look at it. And really what we're saying is this. Okay, I've started by saying when you interpret legislation, you must consider the context and purpose, but you do that after you consider the ordinary meaning. If we look at the flow chart and we consider the identification phase, what we're looking to do is say, okay, here's the operative provision, and you ask yourself, what does it say? What does it mean? Well, that's really asking ourselves, what's the ordinary meaning, isn't it? We do that first, and then we flow across in the exploration phase to consider the context and the purpose. And when we're considering the context, that's where we have to consider the immediate context, what's in the Act, the objects clause, etc. Consider the broader context. And the purpose, again, we consider the objects clause, the extrinsic materials, as Jess said, the explanatory memorandum, case law, etc. Now, there is a risk in this toolkit that everyone will simply produce Michelle Sanson's flowchart. If that works for you, good. But, and I mean this with all due respect to Michelle Sanson, you can do better than this. You can make it more functional. That flowchart is good, but it's a bit abstract. I'd like to see it something much more detailed in your flowchart. Okay, so we've talked about...
Sorry, can I just ask a quick question? We don't actually have to sort of design a flow chart that looks something similar to that. Can't we do it in more sort of a written sort of manner with maybe just a few directional arrows if at most?
Yeah. For me, I mean, what would work for me, that flow chart wouldn't necessarily work for me. I would probably create something that's more like a checklist, which is in a written form. But I'm really flexible in terms of the way you present it. If you want to put it in little boxes with flowchart arrows, or you want to do it in a table, dot points even, if that's what you want to do. So it doesn't have to be a narrative, but I actually want it to work for you so that you can use it beyond this course.
Oh, David,
Yes,
I think
Jess?
you were asking, this is not for the first assessment piece. It's another one.
No, I understand that it's for the second one. Don't worry. I've done a toolkit for John in the past, so I have a little bit of I think I kind of know what he means. Yeah.
Yeah, yeah. It is an advantage for those that have done introduction to law in the past. And you know that what we're really trying to do is create something that you can use beyond this course. That's really important. Now, I mentioned purpose. I mentioned a statute and I mentioned a section number in the statute. Was anyone listening carefully?
15AA.
Exactly, of the Commonwealth Act. Okay, let's have a quick look at that. I'll just share the screen. I'm sure you're all on top of this, but if you're creating a flowchart, a toolkit, and you don't refer to section 15AA, then you're probably missing something very important. So what does section 15AA say? It says, interpretation best achieving the Act's purpose or object. So here it requires you to consider an interpretation that would best achieve the purpose of the Act. That is, the preferred to each other interpretation. The similar wording in section 14A of the Queensland Act. Now this wording is different to the wording contained in the Act before 2011.
So basically, this is saying that we should use what will get the achieved, the preferred outcome, rather than taking it literally. So to use more context.
Yes. So the test is when you're interpreting the Act, and there are different ways to interpret it, what would best achieve the purpose or the object of the Act? So it's really the starting point.
Is that the mischief rule, John?
It is a little bit like the mischief rule. I mean, I'm hesitant to say the mischief rule because that's pretty old fashioned, but it is along those lines, very much so. Yeah. And I know Jess will say, I know where you can find out the purpose or the object. Have a look at the second reading speech. Have a look at Hansard, but have a look at the objects clause. So the test under 15AA, which is the Commonwealth, and section 14A, which is Queensland, is what is the interpretation that would best achieve the purpose or object of the Act? I want you to use those words. Contrast that to the former wording, which was the preferred construction methodology. That preferred construction methodology is still used in states other than Queensland. So it's a subtle difference, but I want you to read around that and have some understanding of the difference between the best achieved, how to best achieve the purpose, which you'll use in Commonwealth and Queensland, as opposed to the preferred construction methodology, which Sarah will use in Western Australia and others will use in states other than Queensland. And you pick up on these differences because they may help you in an argument before a court or to answer a question. That's probably all I really want to cover tonight. We're pretty close to time. I'm going to ask that you continue to read chapter 4 of your text if you haven't already done so. Make sure you keep answering your weekly problems. We know the Act that you must read for the assessment. So if you haven't already started to look at that Act, please do so. Next week, the week after, I won't see you live, but I'll see you in, 3 weeks. All right, any questions before we go?
Yeah, sorry, John, just a question. With the Amendment Acts, because you're saying that they effectively die once they're invoked, how do you reference them and refer to them?
Well, they may not be repealed immediately, but usually, I mean, the Act may state that it has come to an end, but you can still refer to it as the Amendment Act. But the purpose of the Amendment Act is to make the change to the Principal Act. So the theory is that once that change has been made to the Principal Act, we don't have two pieces of legislation dealing with the same issue. That which caused the change to the main Act comes to an end somehow. I hope that makes sense. Grant, would you like to add something? Okay, no, thank you. All right.
Can I ask a quick question?
Yes, David.
With the difference between the states in terms of best achievement purpose as opposed to construction methodology of other states, is there any kind of trend that they're going to follow similar path rather than there be differences between states?
Not that I've seen.
Okay.
Not that I'm aware of, but that may well, it may well be the case. I just haven't seen it. Well, thanks, David. Ben, did you want to ask something?
Yeah, I just put it in the chat, but in part 2 of the assessment, are we required to answer in IRAC form as long as we cover the required elements?
No hard and fast rule, but if you follow IRAC, it's always a pretty safe way to go.
Yeah, cool.
Anybody wish to make any comment about that?
I believe I mentioned earlier asking about doing it in Q&A format, and you said it was fine if you just wanted to go through the process based on the questions provided in the problem, and just write your information based on that. That
sounds fine as well. So I'm always keen to allow you maximum flexibility in terms of your approach. But just as a general rule, Ben, if you go back to IRAC, it's a pretty safe bet. But certainly, I recall that last week, Sarah, you asked the question about Q&A, which was fine by me.
John, I'm not sure if this has already been covered, but when we're referencing an act that has since been amended, do we need to make a note of that when we're doing the AGLC? No,
you don't. It was previously the case that we would refer to legislation by saying, Property Law Act 1974, open brackets, as amended, or Property Law Act 1974, and I forget actually how we did it, but we would bring it up to date. We don't do that anymore. We just treat the amendment as having been incorporated into it. So you don't specifically refer to the Act as it is now in its current form by reference to the amendment. It still keeps its original title. So when we're talking about the Acts Interpretation Act 1901, we know that Section 15AA was not part of that Act when it was first enacted, but we still continue to refer to it as Section 15AA of the Acts Interpretation Act 1901 Commonwealth. I hope that answers your question, Mo.
It does. I just want to confirm that it also works the other way. So if we've got an act, even just like the Work Health and Safety Act, for example, and we're making reference to a provision that existed before an amendment, and then perhaps an amendment comes in and either removes or changes that provision, how do we reference that correctly?
I think that would probably deserve some degree of explanation, and you could make that explanation in the body of the material or by footnote. But theoretically, if it's Section 32, it's still 32, for example, but I would say 32 prior to the amendment in 2017, and make it clear that way. Does that answer your question, Mo?
Yes, it does. Thanks, John.
Thank you. These are really good questions. Thank you. Anything further? We're all good? Okay. Thank you for your participation tonight. Thank you for your careful reading of the material, and we'll see you live in 3 weeks. Otherwise, keep asking questions and making comments through UCrew. People have been making some terrific contributions.
John.
Sarah.
Just as a reminder for everybody, could you either post on UCrew or Moodle or send out an email the day before lectures resume, just so that we don't accidentally get the date wrong?
I will do that. Yep, that's good. Okay, all the best, and we'll see you soon. Okay, bye.